Good afternoon. Welcome to Long Live Third Parties Podcast. Free Press Media Press Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case In re Phillips, 96SW3D418, Texas Court of Appeals, 3rd District, 2002. Friends, today we are going to visit the halls of justice in my state, the state of Texas. The state I have called my home since 2012, that makes it about 8.5 years, is the center of this case. It involves our friends at the Texas Libertarian Party. Since I live in Texas, it is very possible I could run across Texas Libertarian Party members. Maybe members of this case. This case was almost 20 years ago now, so who knows what could have happened to them, but it's possible. So what happened here? Let's read from the record. It says, quote, "Relator contends that William's name should not be included among the candidates for Chief Justice on the November 2002 general election ballot because William is ineligible for that office. The Texas Constitution provides that no person shall be eligible to serve in the office of Chief Justice unless the person is licensed to practice law in this state and, at the time of the election, has been a practicing lawyer or a lawyer and a judge of a court of record together at least 10 years. There is no dispute about the fact that William does not possess a license to practice law in the state of Texas. William, in his response filed in this court, concedes the fact that he is not an attorney licensed to practice law in the state of Texas. Therefore, he is barred by the Texas Constitution from being eligible to seek the office of Chief Justice of the Texas Supreme Court." End quote. In the next paragraph, it discusses how they are trying to get the chair of the Libertarian Party at that time to declare this individual ineligible. This is an interesting strategy to run for an office that you're not eligible for. I'm going to give the Libertarian Party the benefit of the doubt because we like to do that here. So I assume they have a good reason for it. And I like it. I am the type of person who believes in anti-expertology in many fields. Anti-expertology people believe that degrees, credentials, and the like are often puffed up, and a person can possess and demonstrate the knowledge without getting a degree. I myself had a pro se case in which I won. I'm not a lawyer, but I still won my case. So what do you think about this whole predicament? Do you think there should be a law barring non-lawyers from becoming judges? Or how about this specific law? Do you think it should be at least 10 years? I read about on the internet, there's a judge named Jasmine Twitty who is noted, one, for being a woman of color judge, and two, for becoming a very young judge. In her state, they don't require 10 years because she became judge at 30. So what do you think about this, friends? I like what the Libertarian Party is trying to do. And this case, because of the situation, is what they call an open and shut case. There's not much dispute going on here. So ultimately they conclude the following, quote, "Therefore we grant mandamus relief and order De Lamar immediately to declare Clifford F. William ineligible for the office of Chief Justice of the Supreme Court of Texas and to immediately notify Clifford F. William and the Texas Secretary of State Gwen Shea of William's ineligibility to place in the November 2002 general election ballot." End quote. Alas, alas, our candidate here is not going to appear on the ballot. It would rock if he did. It would rock to have fresh blood in a judge's seat. Some people might argue that having a non-judge would bring a fresh perspective. So we can consider that. In the footnotes, they mention that Mr. William is suing to change that law in Texas that requires you to be an attorney. So bravo, William. Bravo, Mr. William. They reference the number, and it's H-02-2167, which looks like an unpublished case. It says currently pending. That was almost 20 years ago. So if it's pending, it's probably resolved by now. I looked for it in Google Scholar, and nothing came up. The case name is Mitchell versus Shea, and because Mitchell is a common name and Shea is fairly common too, a lot of cases pop up, and they don't relate to this. They're unrelated. So friends, let's applaud the Libertarian Party for not only challenging ballot access laws, but also challenging the notion that you have to be an attorney to be a judge. What would happen if a non-attorney became a judge? I've argued before to people who are into the expertology thing, it depends on the field. Doctors are one story, but I got degrees in sociology, so if a non-sociologist became a sociology professor, what's the worst that could happen? Teach a wrong lesson? So let's consider this, friends. Good job, Libertarian Party. Long live third parties. Goodbye.